that a subordinate action or an administrative and executive action robs a legislative guarantee furnished or assured under 26(1). That's another way of looking at it. It ought not to be. 26(1) is a statutory guarantee in terms of a parliamentary statute. That cannot be diminished by an executive action, howsoever wholesome it might be. It has to, as a matter of law, be extinguished by Parliament or by the legislature.
That is why the 2017 Act was...
Absolutely. So that's the point. And that's exactly the point.
Your argument will not hold good.
It will hold good. Let us see. Let us get the contract.
See, once the promise gets extinguished,
yeah,
the guarantee also gets extinguished.
The promise doesn't get extinguished.
No, the legal tender. See, the bank note, once it is no longer a legal tender, that why it is intricacy between the citizens, why it is a legal tender, because it carries with it inherently the promise to pay.
Yes.
Once that promise to pay goes, it's like you imagine the case of a promissory note given in favor of somebody or bearer.
Correct.
So it becomes a negotiable instrument and not restricted by any crossing. Okay. Not restricted by any endorsement. If it is not restricted by an endorsement, the promise, once the promise vanishes, the guarantee will vanish under the law of contracts.
Okay, two answers to that. Answer one, what your lordship is putting to me is actually statutorily captured by 34. Now go to 34. There's no notification under 34. The 34 is the point. The liabilities of the issue department, your lordship will recall, is defined in section 23.
Yes.
I'm now on 34. Separate section altogether on Reserve Bank of India liability. So not the guarantor's liability, but the question your lordship is putting to me, promise to pay. The liabilities of the issue department shall be an amount equal to the total amount of the currency notes of the government of India and bank notes for the time being in circulation. This is a distinct liability, nothing to do with the central government. This is the liability conceptually of the Reserve Bank of India. Sorry.
34 argument is different from your first argument. We are
talking about the first argument. You're right. I agree. So my suggestion is, now let me just meet the points which your lordships have put to me. The question is, will a guarantor continue to remain liable if the primary or the principal, whatever, the promissor, or the promissor is discharged? That's the question. Now, let me tell your lordships, there are two levels of argument. The first is, this scheme departs to the extent that it does because it's a statutory scheme. So you're right that as far as the general contract law is concerned, there may be. But we have two special provisions. One is 26, which statutorily says that and shall be guaranteed by the central government. So that and shall be guaranteed is a statutory liability imposed on the central government. One. The second is that this statutory liability, even if the note disappears, even if the note is no longer legal currency, will still remain. Because what's the point of the guarantor? So let's take an example. I'm sorry.
26(1) contains two components, as you rightly believe.
I believe so.
We are agreeing with you. The first component is that it is a legal tender.
Correct.
And the next component, there is a conjunction and.
Yes.
So long as it is a legal tender and it is guaranteed. That is how you have to read it.
But I think, I'll tell your lordships why that may not be, that's not the understanding of the government. I mean, but that doesn't mean we can both be wrong.
It was never argued.
So no, we can both be wrong.
You are saying that is not the...
The
government did not have an opportunity to answer this. So where is the question of government?
No, they've answered it. The reason I am rejoining to this is because the answers...
This submission is...
Just a second.
This submission is coming for the first time.
No, it's not coming for the first time, my lords.
Mr. Diwan,
Yeah.
this submission that even if it's raised to be a legal tender, still it is guaranteed. Is coming for the first time in the rejoinder.
It is not valid. It's.
I'm sorry.
I have made the.
I'm sorry because all of us have taken elaborate notes.
Anyway, I realized.
We are not stopping you to make that
Yeah,
argument.
very well. I'm grateful.
My objection is only to the statement that the government has not replied to it.
No, okay, very well. So, Manoj, I'll deal with it.
Because the government did not have an opportunity to
please give them whatever opportunity is required. And I'm going to place the government stand on this aspect also very shortly. That is why I requested that the Attorney General submissions be placed. So first and foremost, so now let me just answer Justice Ramasubramanian's point. The issue which is now being raised is that look, and shall be guaranteed by the central government must be or ought to be read as coextensive with so long as it is legal tender. That's a possible
That's
view.
a prima facie.
Yes, prima facie view. Now, I would respectfully submit that I would suggest to the court that please depart from this. Why? Please consider or revisit your prima facie view. Now, why am I suggesting that? The reason I am suggesting that is that ordinarily a statutory a notification by an executive authority, if you agree with me, of course, your lordship may say that this is 26(2) is also legislative in nature. That's a separate issue. If it is an executive function under our schema cannot override and trump a legislative mandate provided by Parliament. So if you have a legislative mandate shall be guaranteed by the central government, it shall remain so. One. Number two, Parliament so understood. How did it understand? It understood it in the manner I am submitting. Parliament, not only in the past in 78, etc., but even now, has so understood that the 26(1) liability continues to subsist and has to be extinguished by statute. That, as your lordship correctly put to me, was the necessity for bringing in the 2016 ordinance / 2017 Act. One and the same thing. So what you have is a situation where I would respectfully submit statutorily the central government's liability guarantee lingers beyond the extinguishment in terms of a notification under 26(2). And number two, there is no necessity for an extinguishment under 26(1) by statute, because you could theoretically have situations where the impact is so minor for some notes which are still left in currency, etc., that the central government says that I am going to continue with my guarantee. Why should I? It's after all a sovereign guarantee. A person comes 3 years down the line or 5 years down the line for a 10,000 rupee note or a 1 lakh rupee note, I don't have a problem. So there's no automatic extinguishment. Yes, I'm sorry.
That is actually,
Yeah.
as Mr. Chidambaram pointed out,
Yeah,
though we call it demonetization,
yeah.
it is always followed by remonetization.
That's the
Therefore,
physical element.
That is how the permission to exchange the
Yeah.
demonetized currency is on account of the remonetization. Therefore, it is not as though the primary liability vanished, but the guarantee continued. Therefore, their exchanging is not the question. It was because of the remonetization that, in fact, the internet we have considered that this currency is actually a negotiable instrument.
It is.
Therefore, if it is a negotiable instrument which can be
But superadded provisions of statute, the Reserve Bank of India Act.
34 stands on a different footing. But 26(1) you are reading, we are not.
Anyway, your lordships have followed my
But
point.
in any case,
Another way,
in any case, on 30th of December 2016, it is that guarantee extinguished.
Correct. So that supports me. So I'm coming to that. The point I'm making just now is let us understand the statute. There are distinct concepts. Your lordships may accept, reject. That's up to the court. There are distinct concepts of legal tender. There's a distinct concept of central government guarantee. And there is a process under 26(2). And I have made my submission that a positive recommendation by the Reserve Bank of India is a condition precedent for the purpose of exercise of 26(2).
No,
Now I have 2 minutes.
That is
Sorry.
also agreed by Mr. Gupta that there are two requirements
Right.
under section 26(2).
Recommendation
Recommendation and decision.
decision. Yes, correct. And if both, but if there is no sorry.
So there doesn't appear to be a quarrel on that there has to be a twin requirement under section 26(2).
No, I'm not suggesting. I think a specific question was put to us that absent a recommendation, your lordship was obviously contemplating all sorts of situations. So I'm just putting it down in the simplest manner in which I can, that a positive recommendation by the central board on our understanding of the law is a condition precedent for 26.2. The reason I'm making this answer and putting it in plain terms is there was a lot of submissions, there were a large number of submissions made, monetary policy, fiscal policy, integrity of India, this, that, and the other. Maybe you can do it. Now, let me just answer that issue squarely. This does not mean that Parliament or the executive through an ordinance route is robbed of the power in an exigency of waiting for that central board to make a recommendation. No. The administrative route under 26.2 is not available. The ordinance route or the parliamentary route for the purposes of it has guaranteed
specific provision as has been made under the now 1917 Act. So if your argument is to be accepted, then those notes of 10,000, 5,000 denomination still exist. And if somebody has, then the government is guaranteed to pay it. If the argument is to be accepted, it will have been stretched to that.
No, maybe we'll see that. I'll examine that and I'll come back to your lordships on that. But now, fortunately for me, not only does the union government say,
But in any case, what turns on it?
so we'll come to that in a bit. We'll come to that. But now let us see what the ordinance says. Let's see what the ordinance says now. So I am requesting your lordships now to take the ordinance. Please, that's at page 38 of my compilation 1. We are looking at the ordinance, not the act. The act is in same terms, but the ordinance came first. Parts. Page 38, please. Parts of the preamble. See the second recital. What is the ordinance to do? An ordinance to provide for the cessation of liabilities on the specified banknotes and for matters connected therewith. So this is their view. They may be wrong, of course, but this is the target, the object, to seize the liabilities on the specified banknote. That's the objective. Now see the last recital on the same page, page 38. And whereas, not it is desirable, whereas it is necessary to have clarity and finality to the liabilities of the Reserve Bank of India and the central government arising from such banknotes which have ceased to be legal tender on the basis of the said notifications. So it's very, very, very clear. There's a reference to the notifications of 8th of November 2016 in the second recital. Therefore, you have this particular ordinance. Now look at section 3 or ordinance clause 3. Yes, your lordships also had a question to me with regard to when it shall come into force. So please just see that the ordinance comes into force on 31st December 2016. Much turns on this, and appointed date means 31st day of December 2016. Because please recall the Prime Minister's words. The Prime Minister's words, your lordship recall, which I read to you. Your money will remain yours. You need have no worry on this point, on first statement. And the second statement he made was that, look, at Reserve Bank of India counters, even after 31st of December, you will still have your chance to change your money. So, and then you have that definition of grace period specified by the central government by notification. Now, please focus on 3. Look at the marginal note. Specified banknotes to cease to be liability of Reserve Bank or central government, both. Now, let us see. On and from the appointed day, notwithstanding anything contained in the RBI Act or any other law for the time being in force, the specified banknotes which have ceased to be legal tender. First concept, ceased to be legal tender. In view of the notification of the government in the Ministry of Finance, 8th November 2016, issued under subsection 2 of 26 of the Reserve Bank of India Act, shall cease to be liabilities of the Reserve Bank under 34 and shall cease to have the guarantee of the central government under subsection 1 of section 26 of the Act. So this is the extinguishment.
And this is with effect from 31st of December.
Absolutely. So till 31st December, their liability remained. So I'm answering the question. Their liability remained in, the concept is twofold. One, as your lordship correctly puts, 31st December. But then you recall there's also a grace period concept in the statute itself. So that liability and the guarantee may extend to the grace period in notified situations. But the important point is the one which you make, namely that on and from 31st of December, what happens because of this statute? Has it ceased to be legal tender because of this statute? No, that has already happened on the 8th of November. What has happened by this is not executive. This is statutory in the sense legislative ordinance. Sorry, legislative. And something further and in addition, what I'm trying to emphasize is this is not the same thing which has already happened. 26(2) notification, which is the procedure and the mechanics, and which they say was followed, etc. We say not followed. That's a separate argument. That extinguished the legal tender. You couldn't accept it. I couldn't go. Your lordships asked me that, look, could you pay a staff member or an employee after this date in these currency notes? The answer was no. rightly said by the Reserve Bank, because it had ceased to be legal tender. But the liability remained right until 31st of December, and for good reason.
RBI and
There's another answer to the question your lordship put to me.
the liability of both RBI and the government.
Remained
Therefore,
till 31st December.
therefore they coexisted. You understand?
Of
That is
course.
why.
Yes.
That is why it did not. They were not
There is no severance.
separate bogies. There was no severance of. See the liability of. That is why from the beginning we have been saying. See, look at this. A currencies, a banknote ceasing to be a legal tender is
Yes.
item number one.
Correct.
RBI's liability getting wiped out from the balance sheet is another one.
But it's a liability. You're right.
Therefore, the liability of both RBI and the government as a guarantor got wiped out together, not separately.
Yeah, that's the scheme.
No, you started off with saying that
No, let me just tell your lordships in the plainest terms.
Why learned brother?
Yeah.
On the basis of contract, that said that once the promisers
It is called.
promisers cease
So
to
let
be
me
the
answer
person
it.
of
Let
guarantor.
me answer it directly in terms of contract. Contract law, one, is subject to statutory law in certain situations. One. Two, these are separate liabilities and guarantees. One government, the other as far as the RBI is concerned. That's the second point. Parliament could very well choose to extinguish both together. But that does not mean that they in an appropriate or other case may choose to do it differently or distinctly. Please don't rob Parliament of that power. Please, so the answer to the question is
That
why,
question
sorry?
doesn't call for consideration as to whether it can be done separately or not.
That in an appropriate case, here that doesn't trouble us.
We can't decide on the basis of hypothetical situation.
You should ought not. I said that your lordship certainly ought not. That they have done it here. What I am suggesting is that they have done it here and they've extinguished. Sorry.
I'm sorry, I'm repeating again and again.
Yeah.
Even if we accept your argument for a sake,
Yeah.
that the guarantee and even suppose even the promise
Yes.
exists till 30th of December.
Yes.
And once an ordinance comes into effect,
Yes.
what is the then?
What is
I'm
the?
not saying, but see, there are two. Sorry.
Please develop the further argument.
So I'll state the point straight away, Manoj. I've mentioned that in the answer. I am not for a moment saying let me answer the question. The answer is twofold, and then but please allow me to complete the argument. The answer is one. This came in on the 30th of December with a hard stop on the 31st of December with a grace period. So I'm going to request the court to interpret the grace period in a manner which is just and reasonable. Because that's in section 4, my submission is going to be having regard to the fact that the liability was extinguished. The assurance of the Prime Minister, it would be completely unreasonable, or to borrow the expression, manifestly arbitrary and unjust to have just 24 hours to change. Because the entire regime until then, as understood with the grace period, is that this is going to extend. This is one part of the argument. The second part of the argument, and I'm going to pick up the Attorney General's note right away. I am going to respectfully submit there ought to be clarity as laid down by this court. And that's the second part of the argument, because I have to deal with the arguments which were made in writing. So now I have mentioned to the court now let me just sum up on this part, then I'll come to section 4. What section 3 does is, therefore, it only does one thing or two things. Extinguishes central government guarantee, extinguishes RBI liability, and therefore builds on what has already happened. So what does it not do? And that's very important. It does not validate anything which has happened earlier. One, there is no question of merger. Number two, and that's my respectful submission. Now please pick up, because before I go to section 4, please pick up the Attorney General's submission. Only 2 paragraphs, and those are para 2.5.3 and 2.5.4. This is what I am addressing now in all this submission. Please go to 2.5.3. This is the additional submissions of the Attorney General. If it's the same copy that I have, it should be on page 11. Only 2 paras I'm going to read. It's a para beginning nevertheless.
2 point.
5.3. Manoj, it's titled Additional Submissions.
Page 11.
Yes, and it's handed in on the 5th of December.
This was on the main arguments were advanced on this basis.
Yeah. Your Lordships have it? Correct. So now just let's read it. Nevertheless, the submissions advanced by the petitioners carry no weight, insofar as they fail to appreciate that even in the present case, the government exercise of powers under 26(2) has been incorporated by reference. Please mark that. First legal concept, incorporated by reference into the specified Banknote Cessation of Liabilities Act 2017, and therefore the same was effectively been validated by an act of parliament as well. So this is the second legal concept in this one sentence 2.5.3. Incorporated by reference, validated into an act of parliament. 2.5.4. The notification of 8th November 2016 has been affirmatively referred to in section 3. By such affirmation, Parliament can be said to have taken into account the notification and its implementation scheme. As a result, since the notification has, now this is the third concept, merged in the parliamentary law, it has ceased to exist independent of legal instrument. It has ceased to exist as an independent legal instrument. It must be taken that regardless of any issue relating to the exercise of power under section 26(2), the decision to withdraw existing series of certain denominations from legal tender must be treated as a parliamentary plenary declaration. So there are 5 concepts, maybe there are more. Incorporation by reference, validation, merger, cease to exist, the notification itself has ceased to exist as a legal instrument, and parliamentary plenary declaration. Now I'm going to respectfully submit very quickly that each one of these is incorrect in my respectful submission. First of all, I would respectfully submit that this is muddling up all sorts of legal concepts which can't be muddled up in these 2 sentences. So let me specify. First concept, incorporation by reference. Incorporation by reference is a concept, is a legal concept which this court regularly applies, where a statute doesn't want to repeat all the statutory provisions again and again because they are already contained in another statute, and therefore it makes a reference to that particular statute. And then there's a whole body of case law as to whether amendments to that other statute get incorporated here or not. That is the concept of incorporation by reference. Here there is no incorporation by reference. There is certainly a reference to the other notification which was in the executive realm. This ordinance is dealing with legislative power, completely separate and distinct. Second concept, validation. Validation arises when something is declared ultra vires. It may be ultra vires for a variety of reasons. There's no concept, no court had said that this is ultra vires. No one at that point of time requiring validation. In any case, 26(2) is an executive power, doesn't confer any authority on parliament. There's no question of validation. So that's my second answer. Third concept is merger, merged into parliamentary law. My respectful submission is this is 2 distinct things. One was an administrative action under 26(2). Another was an extinguishment of liability under 26(1) and 34. There's no question of merger. The fourth point is ceased in law, it has ceased to exist. I think this is, well, I don't think this is even stateable, frankly, except that the Attorney General has stated it. It has its life. It had complete impact across the country, and it had full force of law, subject to, of course, what your lordships now hold. It had the full force of law, and it operated immediately on being issued on the 8th of November 2016 until the 31st of December when there was a period, but it ceased to have any legal tender basis. So this to say that it merged into a statute is again, in my respectful submission, ceased to be an independent, it continues as a legal independent instrument. The bullet has been fired. It has, in the form of the notification, it has carried its course and it has done what it has done. It doesn't cease to it. It doesn't have any impact or effect later on because it was self-contained at a certain level. But legal tender immediately stopped. And finally, it must be treated as a plenary parliamentary declaration. I don't think any plenary parliamentary declaration is made or even attempted to be made by this bill. So that's my respectful submission. Now we come to section 4. Now, before we come to section 4 of the ordinance,
How can it be given that by a plenary parliamentary declaration.
Yeah, there is none.
No, a specific statement is made that from 31st of December so and so,
Yeah,
all these specific banknotes shall cease to exist.
yeah,
And the guarantee and the promise
absolutely right.
shall cease to exist.
So just see the
regarding
please, it's
notification.
two different things, my lords.
It is
Where's the
regarding-
question of merger cease to exist? Please, what the ordinance does is it extinguishes. Sorry.
What has been done
Yeah.
under the notification of November,
Right.
what was provided was that
Legal tender.
it shall cease to effect from legal tender.
Correct.
And it granted a window till
Right.
30th of December to exchange the notes.
What does that mean? The guarantee was still there.
Guarantee was there.
Yes. Why was it there? Because that's why you could exchange notes.
And therefore, because they,
So-
you see the fourth,
No, but may I just, sorry, with your permission.
you see the fourth whereas.
Yes.
And whereas it is necessary to have clarity and finality.
Finality, yes.
So the parliament might have thought that there might be some ingenious arguments, and therefore to take care of that.
No, this actually,
a specific ordinance.
yeah. So I'm actually obliged to your lordship's question because I think it answers the earlier issue
Yeah,
which I
if
had. Sorry.
your argument is to be accepted,
Yes.
it will have so much ramifications because under the 1778 Act, there is no
No.
such declaration under section 26 and 34. And those 10,000 notes will still have to be honored and by the government.
Sorry. No, so let me just, Manoj, I think part of it is answered, part of it is answered. The fact that the guarantee and the liability continue on and after 8th of November 2016 is now I'm supplying two more reasons. The first reason is it's clear from the fact that they exchanged notes. That's reason one. And the second is,
And the notification itself provided.
yeah, of course, because of a guarantee which was extant and outstanding, and because there was a liability which was extant and outstanding. That's the reason. But there's another reason. The second reason is that you could not have an executive direction which invalidates a statutory obligation under 26(1) and 34. That's the elementary proposition which we are canvassing. Of course, there may be some subtle argument under contract law, but the legislative argument is, or the administrative law argument is, or the constitutional architecture argument is that you cannot have executive action nullifying a statute under the very statute under which the executive action is issued.
I've been repeatedly saying that even if you accept your argument,
Yes.
that the November notification.
Correct. So now I'm only on that. Now I'm only on that.
Under the said notification, also the deadline
Yes.
was the same, and under the ordinance also the
All right. So now let's answer that. Now we are focusing on that. So first, your lordship, of grace period.
Are you trying to say?
Yes, sorry.
Are you trying to say that it was because of the guarantee which continued,
Yes,
that there was provision made for exchange of notes
absolutely.
and the banks
Absolutely.
see, they ultimately, because the banks accepted the notes which ceased to be legal tender and they gave valid notes, the new notes. Otherwise, the banks had no duty to exchange the notes which the central government had said had ceased to be legal tender.
That is absolutely my point. My point is that the guarantee and the liability continue.
The provision for exchange is a continuation of the guarantee.
Absolutely.
The guarantee is extinguished. You may say that.
No,
That is my very submission. Manoj, let's be clear. Manoj.
provision for exchange.
Yes, sorry.
In the notification.
The provision for exchange is a
Yes.
continuation of the primary liability itself, not
Yes.
just the extent of the guarantee.
Government guarantee,
No, the liability, the RBI itself continues.
34.
Therefore, the notification did not extinguish the liability. 8/11/2016,
It could not.
because they said the window is open for exchange. Unless, if suppose the liability is wiped out on 8/11, they can't re-exchange the notes. Therefore, that is the reason why the liability continued. Legal tender also only ceased to exist.
Correct. The liability, otherwise they would not have.
Not just the
accepted-
guarantee, not just the guarantee,
accepted
but the
bank-
liability.
The
Not
bank,
just the
I
guarantee.
am in 100% agreement with the observation made that on and after 8th November, according to me, the liability continued, the guarantee also continued, both continued. Eventually, as Justice Gavai has correctly pointed out, extinguished on 31st December 2016, subject to judicial review by this court. But that is the scheme which was followed. So that is why, because I'm obliged for that question, the reason why they were obliged, apart from being in terms of the notification itself, there was an outstanding statutory notification. Your lordships have noticed my point. I think an executive that sort of the tail card. For the power coupled with duty. Now, for that, let us go to page 44. Because I'll just indicate what has happened here. I'm now responding. I thought it was fairly insensitive, but I mean, we can't use stronger expressions than that to describe the attitude of both the Reserve Bank of India and the Union of India. These are genuine cases. What are you going to do about them? Now, please see 44 first. Go to page 44. Now, this is what they do on 30th December 2016. Now, I am relying on a part of this notification. And I am going to show your lordships 2-3 ways out. If we are right. Please go, same compilation 1. Please go directly to 44. Now, just see the first part. In exercise of powers conferred under clause B of subsection 1 of section 2, read with clause 1 of subsection 1 of section 4 of the specified notes, that's ordinance, the central government hereby specifies in respect of citizens of India referred to in clause so and so of the set. So this is issued by the Ministry of Finance. Please note that this is not an RBI notification. It's a Ministry of Finance, Government of India notification. Now see this, I am quite happy with A, who is a resident of India. So they are specifying the grace period, who is a resident of India for the period ending 31st day of March 2017. And B, who is not a resident of India. This is what covers me. A period of 30th day of June 2017 as the grace period for the purpose of the said ordinance. Now, so far, I am in a very happy situation because it's still the 30th of June 2017. I'm in a KYC account. I've got the money, this, that, and the other. There's no problem at all. All right. This is one aspect. Now they have a proviso. So there are 2 ways of reading this proviso. First, let me read it and then make the submission. Provided that the amount in the specified notes rendered does not exceed the amount specified under Regulation 3 or Regulation 8 of Reserve Bank of the FEMA dated 29 December 2015, made under provisions of the Foreign Exchange Management Act, and the conditions specified therein are complied with. Correct? This is the proviso. Now, first submission. This proviso can only apply to people who during that period were out of the country. That's one. I am not there. I was sorry. It can only be applied. My mistake. It can only apply to people who carried currency out of the country. Who carried currency out of the country and who were away. The proviso. Well, let's see. Please see. Who is resident in India for a period ending 31st day of 27 and who is not resident 30th June 2017. So I am saying let us go by this part of it. It will be enough. It gives me relief. There's no problem. Because I landed well before 30th of June 2017. In February itself, I tendered my money in one case where, so there is no problem. And insofar as for people who are out of India, correct? So there's no problem. Now, what is the effect of the proviso? The proviso restricts it to someone who carried an amount abroad and brought it back. Now, I was not in that category. My money was lying in India. So therefore, the proviso has no application. So this is one way your lordships can grant relief to citizens who had left the money in India and were away from the country during that period. What is the method? The proviso does not apply to people who had left the money in India. That will give a huge amount of relief to people such as myself, people such as who Mr. Rao was representing, etc. Sorry.
What would be the mechanism?
No,
to find out that those non-resident Indians had genuinely kept the money when they were traveling out.
So they have to be satisfied. That will be on a case-to-case basis.
The notification are for 2 classes.
Yeah.
Insofar as the persons who are residents in India, there is no such restriction.
There is.
No. There is subsequently it is clarified.
No, we'll come to that. Manoj, your lordship is right. There is that clarification which I'll deal with.
For resident in India,
yes.
There is no limit.
Yeah.
There is no requirement for declaration.
Correct.
Then the proviso is applicable only those persons who are NRIs.
Right. So how? So what about an NRI who has left it in India? Well, I mean, that's like, can you imagine what a huge group of people that is?
Milord, even NRIs don't have a
NRI
restriction.
Sorry?
Even NRIs don't have a restriction up to 31st of December. The
No,
rest,
no, 31st December, we are talking about grace period.
Then Mr. You
Let-
are that asking them to return at before 31st of December.
is unreasonable, manifestly arbitrary. and
Yes, it is manifest or extraordinarily cold-hearted.
Where,
Maybe the tickets would have costed them more than
Milord,
1.5 lakhs.
Milord, what was he doing for these 2 months when the notification said that he will get this opportunity only till 30th? Can he say that he can
It's an
enforce?
astonishing submission.
Can he say that
It
he?
is the most callous submission on behalf
Milord,
of RBI.
Merely
To make
using the word
submissions
callous
like
will
this.
not help.
Atmosphere outside is quite pleasant.
And polluted.
So according to him,
Yes.
this has to be linked with right to life. Right to,
Milord,
he has a right to live with dignity, and
Yes.
therefore he is not expected to come back for this paltry 1.6 lakhs. When the tickets itself would have costed him more than that.
Milord,
No, it's much more. Actually, it's much more than that. I will explain that to you.
he has come back in February. He could have come back in November. Milord, the question is whether no opportunity was given to him or not.
We have noted your argument yesterday that till 31st of December,
Yes,
everybody had opportunity to do away with everything.
everything.
Now, let me just deal with this argument right away. This is a wrong submission on facts which is made because until the 30th of, so please note this now.
Till 30th.
Until 30th of December, the assurance given by the Reserve Bank of India and the Prime Minister of India, no less, was that you will have an opportunity even past that date. And I'm going to point that out.
Milord,
And
we
it's
have,
only on 30th of
This
December they
argument
said
has
there's
to
a
be-
hard stop on 31st December. Is that reasonable?
We permit you to address because
Milord, this is a rejoinder. Milord, it is very difficult for me, Milord, to collect all this material and give it to your Lordship today. So I'm, Milord, the ones which are obviously incorrect, Milord, please permit me to point out. The notification said that exchange will be permitted only up to 30th December. So this argument that Reserve Bank said that he will get after 30th December, that the Prime Minister said that he will get after 30th of December, all this is, Milord, irrelevant. The notification which is the law said 30th December. He knew that.
When did that notification come?
Milord, 8th of November, this is the first notification.
Oh, you're referring to.
First notification.
No, there was another notification of 30th of December.
No, the
Yes, I'm coming to that.
I'm sorry, Milord,
that is
30th,
what you are reading.
30th December, Milord, is grace period notification.
Grace period.
But Milord, there is a primary notification which gave them the right to exchange whatever they wanted to. And Milord, the answer to your Lordship's question as to why would banks honor after Milord 8th of November is because the notification said they will honor. Milord, the notification said so. They will honor under these circumstances from the beginning.
That is
So it's the
because
law.
Central government has guaranteed the currency.
Milord, it doesn't matter whether they
Liability.
Milord, it doesn't matter whether there is a liability, it doesn't matter whether there is a guarantee. The notification says,
Gupta, since some new points have come, we will
Yes.
grant
yeah,
you some.
all right, very well.
Now let's just get rid of this point because I mean, I find it in plain English, but anyway, go to page 27. Let's just answer this point. Just go to page 27. Paras 9 and 10 first.
You already read it to us.
I know, but then it's being said over here that on 8th of November. Now look at his statute. Look at the statutory notification issued by the ministry. Please see this clause 9. Why is the statement being made contrary to the statutory notification on page 34? Look at clause 9 on page 34. Any person who is unable to exchange and deposit the specified banknotes in their bank accounts on or before the 30th of December shall be given an opportunity to do so at specified offices of the Reserve Bank of India or such other facility until a later date as may be specified by it. So this is the government of India making an assurance to all people. And I'm told just now that on the 30th of December, I should have bought a ticket which brought me back into India by the 31st of December.
How did you read?
I mean, this is an astonishing submission by the Reserve Bank of India, contrary to the Ministry of Finance statutory notification.
How do you?
So the whole scheme is that if the Prime Minister says it, the statutory notification says, we are not going to take away your money after 30th of December either. This is what even after 31st of December, till 30th December was given time. But this is a statutory notification on the basis of the Prime Minister's statement. And you suddenly change the goalposts on the 30th of December and you say that now we are not going to do it even if you are abroad. What was I to think when I was overseas? Apart from the points which your lordship correctly put to me, what I was to think was that, look, this is a reasonable government. I have a constitutional right to property. I have my money which has been withdrawn and which is lying at my home. I'm not required to rush back and spend whatever amounts which are there, provided I get a ticket. I will come back. I came back in February. Now, please go to the statement, therefore. So, one part which I'm suggesting now, I'm suggesting to the court that this proviso at page 44 applies only to currency gone out if there is a case made out of a person who has left the currency in India. It ought to be accepted because the proviso has no application. That's my first submission. So please clarify that. That will give a lot of relief to a lot of people. The proviso obviously applies only to people who go out of the country and who come back. That's one reasonable interpretation which can be given. I would respectfully submit. I would commend it to the court. The second reasonable interpretation is, now please go to bottom of page 47. These are the RBI guidelines. Where do they get this from is the question I ask myself. For non-resident Indians. Now, please see, so there is paragraph 3.4 at the bottom of page 46. Your lordship, see, second last line on 46 is 3.4. Please note that my relief which I sought was through that was strike down this insofar as it applies to me. Now in 3.4, the terms are specified, and for non-resident Indians, tenders should be submitted along with the tender form, Roman 2, Roman 3, tenders will be restricted to a maximum of 25,000 per individual, depending on whose notes were taken out of India. So again, my submission is, all these requirements of certificate of Indian customs on ascertaining that the tenderer was abroad and had a KYC, please interpret this particular set of directions given by RBI as confined to people who took currency abroad, but it is silent on people who left currency here. And I think, in my respectful submission, I don't know, I suppose jet-setting lawyers can go up and down the country and buy a ticket immediately and come back, etc. But I think the government of India adopted a very reasonable stand initially when they kept it open because they were respectful of rights. And to answer Justice Gawai's question, I think the presumption has to be that citizens who come and who have genuine cases, if they are able to explain it on the strength of an affidavit, is bona fide and on the basis of passports, etc., and there is no history of them being a history cheater or something, should be presumed not to be a terrorist, someone engaging in trafficking or counterfeiting. I mean, these are amounts which are a huge amount for the individual himself or herself. And to be just, so therefore, I come to the point that this exclusion in the RBI, so that's the next route which your lordship can follow. Clarify the notification of 30th of December. Another route can be clarify that this RBI notification applies only to situations where currency was taken out and brought in. For those who say that the money remained over here, they must be given an opportunity. Otherwise, it means that there's a huge class of people. Now I'm in terms of the notification. It's a huge class of people unfairly excluded from the process. And it is no answer to say that you had 50 days to come back to India. It's no answer to say. This is a very patronizing attitude on the part of the RBI that, look, I will issue a notice. And how could I? The submission made was hope of extension. There was no hope of extension. My rights were not founded on a hope of extension. They were founded on the basis that the Prime Minister and the statutory notification issued by the Ministry of Finance on the 8th of November both said that there will be avenues available to you even after 30th of December. And it came through. So why exclude me is the question I ask myself. Such exclusion is completely heartless and completely arbitrary is my respectful submission. Now please go to section 4. Now I'll wind up on section 4 and then a few other small points. Section 4 at page 40, clause 4 of the article, page 40. So does your duty to cover, your duty to have an appropriate notification, does it not extend to situations like us? That's the question. Power coupled with duty, 4.1. notwithstanding anything contained in section 3, the following persons holding specified banknotes on or before 8th of November 2016 shall be entitled to tender within the grace period with such declarations or statements at such offices of the Reserve Bank or in such other manner as may be specified by it, namely, please go to Roman 2, such class of persons and for such reasons as may be specified by notification by the central government. So my first submission is excluding a category of NRIs who had money in India is arbitrary in our respectful submission. It is so manifestly arbitrary that it is under-inclusive, going under the traditional classification test. NRIs form a single class. Some carried the money out, some left the money here. Both have to be treated similarly. You cannot create an artificial barrier or an artificial subclass and extend the grace period only to people who carried money abroad and didn't and declared it in the customs, etc. when they came back. So it is under-inclusive, is my respectful submission under the classical test. It's manifestly arbitrary to exclude us as a whole category. Apart from the other categories mentioned by Justice Gawai, there's so many people who may be medically unable. There is another person over here, for example, whom Mr. Prashant Bhushan represented, Sarla Srivastava. Her husband had died in 2016. And in 2017, January or February, what was it? January, when she was cleaning up some trunk, or what is the correct expression? Steel trunk. She was cleaning up a steel trunk. There was money which was discovered, 1,79,000. It's a lot of money for her. Her husband had died. Now, this is in January. And she wrote to the Prime Minister and said, please help me out, which was referred to here and there. And then now she's in court. And this, therefore, is a very, so that exclusion for genuine and hard cases, I would respectfully submit, puts an even higher duty on the government to be sensitive to such cases and to create an appropriate subsection. So my submission is central government is wanting in its duty. The second submission is that subsection 2 is in any case a standalone provision. Your lordships have said that we prima facie, I mean at the opening, not after, before hearing them, felt that look, this is something power coupled with duty which even the RBI can exercise. But RBI has also acted in a manner which is incorrect. Now I'm done with this section 4 part also. Now 2-3 small points remain. The first is on judicial review, and I want I'll just sum it up. There appears to us to be a yawning gap of persons not covered, a huge gap. I've indicated 2 or 3 situations. There ought to be at least some broad categories to capture genuine cases such as this. So one part of the argument is yawning gap. The second part of the argument is in any case, grace period has been extended to all NRIs till 30th June. Why deny it to me? Just because I kept my money here. That's the second broad argument. Now I'm on judicial review. Judicial review, your lordships know, have been held to be part of our basic structure of our constitution. There's a whole bunch of series of Supreme Court constitution bench judgments on this point. Now, what's the issue over here? Judicial review is being disabled at 2 levels, and I would respectfully submit, you please, your lordships will have the time to reflect on it and to decide what the correct course of action is. Just take a hypothetical situation. I'm not saying this is the situation here. Supposing under 26(2), the government had handed over minutes and agenda notes and notice and recommendation. And in this hypothetical situation, supposing all 4 of them were blank sheets of paper, what would the court say? The court, does it have the question I'm asking myself is, the part of judicial review and your lordship's oversight, judicial review oversight, limited as it is, surely extends to an informed decision on parts like this. And an informed decision can be arrived at on an issue like this in exercise of your power of judicial review. The request is don't diminish the court by allowing them to keep these documents, which are not some high security documents. They are administrative documents. They must be they ought to be disclosed. They ought to be perused by the court. Why? Because it reduces and diminishes the power of judicial review. So please consider that facet as well. And I would be greatly obliged. I think the part on guardrails and to lay down defining parameters is an aspect which survives apart from individual cases like mine where there may be 1,62,000. I believe it's an imperative. We are way past this stage where you can have some diktat issued by some ruler or something like that and say that what I say is final. No, it is subject to being reasonable, fair and just, whether it is statutory or otherwise under our constitutional scheme. So how is this power of judicial review to be exercised unless these basic documents are made available to the court? So I would respectfully implore the court that please also, as far as guardrails are concerned, and what are the parameters, whatever appropriate expression your lordship would like to use, please use it. The other element is on the question of academic. Your lordship correctly said that your lordship yesterday itself in the course of Mr. Chidambaram's submission said that the Bomai case is surely an answer to a situation like that. But there's a useful passage in, the Attorney General referred to a New York Court of Appeals judgment of 25th of September 1877. One of the judgments cited was a New York Court of Appeals, 25th September 1877, in the People versus Amos Clark. And it had a very good line. And I think the reason why the Attorney General probably submitted this was to show the importance of this principle, which was laid down in this 1877 judgment, and how it ought to commend itself to the court. The test laid down by the New York Court of Appeals was, can effectual judgment be rendered? And I believe effectual judgment can be rendered